Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, listener, learners, officials, those who are listening, watching YouTube channel 3M Creator, I heartily, cordially welcome all respected doctors and directors, adorable ministers and managers, honorable advocates, advertisers, administrators, advisors, the most honorable President Prime Minister Modi ji. I, Dr. Rakesh from USA, heartily, cordially welcome. It is really nice time, nice place, nice action. Today we are defining our holy Indian Constitution. What our great men, freedom fighters, free thinkers explained for the welfare of our society and nation. What have they written? It is really praiseworthy, admirable, appreciable for the cosmopolitan outlook, for the international outlook all over the world. Wherever our scholars are busy in doing research, investigation, then this Indian Constitution help them. This holy Indian Constitution help them in understanding the internal constitution of the soul or spiritual power that God gave, bestowed this human being since time immemorial. Let us try to describe our language, literature, and related grammar that is used in explaining, describing, defining our holy Indian Constitution. Before that, we have to discuss the provisions made in the Code of Criminal Procedure 1973 regarding compounding of offences. What is quenching? What offences can be compounded? Let's explain the effects of mitigation. Compounding of offences is an important form or undertaking for the establishment of harmony between the parties. Love, affection, and harmony are the foundation of social harmony. When a dispute arises between two parties, or the offense of one person causes loss or damage to the other person, animosity arises between them, the feeling of love, affection and harmony ends. This situation sometimes becomes fatal for the family and society as well. Therefore, to avoid such a situation or to restore love, affection, and harmony, efforts are made to reconcile the disputed parties. The name of this effort is compounding of offenses, for example, compromise or resignation. Compounding literally means agreement or resignation. Compounding of offenses means subsection. One is mentioned such offenses in which the aggrieved party can settle without the permission of the court. And subsection 2 expresses mention such offenses which can be settled only with the permission of the court. Singheshwar Prasad Ali Hussain AIR 1929 Patna 512. These offences are as follows: compounding of crimes. The offence is punishable under the section of the Indian Penal Code 45 of 1860, specified in the first two columns of the table, may be compounded by the person mentioned in the third column of that table. Offences, the section of Indian Penal Code applies. The person by whom the offence can be compounded. Uttering words with the intention of hurting religious sentiments of any person, etc., voluntarily causing hurt. According to the section of Indian Penal Code 298, person whose religious sentiments are intended to be hurt. Voluntarily causing hurt, in it the section of Indian Penal Code applies. 323. The person by whom the offence can be compounded, that is the person to whom the hurt is caused. Voluntarily causing hurt, in the section of Indian Penal Code 334, that the person to whom the hurt is caused. Voluntarily causing hurt on provocation, in the section of Indian Penal Code 335, that is the person to whom the hurt is caused. Wrongful restraint or confinement of a person, in the section of Indian Penal Code applies. 341, 342, that is a person who is blocked or confined. Wrongful confinement of a person for 3 or more days, in the section of Indian Penal Code 343, that is confined person. Wrongful confinement of a person for 10 or more days, wrongful confinement of a person for 10 or more days, in the section of Indian Penal Code 344, that is a person who is blocked or confined person. Wrongful confinement of a person for 10 or more days, wrongful confinement of a person in a secret place, in the section of Indian Penal Code 346, that is a person who is blocked or confined. Assault or criminal force. in the section of Indian Penal Code 352, 355, 358 that a person who has been attacked or used criminal force, theft in the section of Indian Penal Code applies 379, that is the owner of stolen property. Dishonest misappropriation of property in the section of Indian Penal Code 403, that is misappropriated property, property owner. Criminal breach of trust by courier, Ghatwal, etc. In the section of Indian Penal Code 407, that is misappropriated property owner. Dishonestly receiving stolen property knowing it to be stolen in the section of Indian Penal Code 411, that is the owner of stolen property. Assisting in concealing or disposing of stolen property in the section of Indian Penal Code 414, that is the owner of stolen property. Knowing it to have been stolen, cheat in the section of Indian Penal Code applies 417, the person who has been deceived. Compounding, when an offense is compoundable under this section of abatement of such offense or of attempting to commit such offense, when such attempt itself is an offense, or where the accused is liable under section 34 or section 149 of the Indian Penal Code, can be done in the same way. When that person who would otherwise have been competent or compound the offense under this section is under the age of 18 years or is rude or lunatic, any person competent to contact on his behalf may, with the permission of the court, such can compound crime. When the person who would otherwise have been competent to compound the offense under this section dies, the legal representative of such person as defined in the Code of Civil Procedure 1908, 5 of 1908 may, by order of court, compound such offense. When the accused is committed for trial or when he is convicted and the appeal is pending, the compounding of the offense shall not be allowed except by the order of the court to which it is committed or before which the appeal is heard, as the case may be. Acting in the exercise of its powers of revision under section 401, the High Court or Court of Session may order any person to compound any offense which that person is competent to compound under this section. If the accused is by reason of his previous conviction for any offense punishable either with enhanced punishment or with punishment of a different description, such offense shall not be compounded. The effect of the composition of the offense under this section shall be the acquittal of the accused from whom the offense is compounded. The offense shall be compounded only in accordance with the provisions of this section, except not otherwise. It is to be mentioned here that only such offenses can be compounded by which they are mentioned in section 320. Sholapur Municipal Corporation versus Relicor, AIR 1970, Bombay, 333. In the matter of Vasan versus State of Kerala AIR 2014 SC 1437, it was held by Supreme Court that in matters of compounding of offences, the provisions of Section 320 should be strictly observed. It is not allowed to deviate from them. When can a settlement be made? Compromise in an offence can be made at any stage of the trial. For example, before passing the sentence and even at the time of writing the judgment. Aslam versus Emperor ILR 45 Calcutta 1816. It is worth mentioning here that even attempts at compoundable offense can be compounded. Who can compromise? Generally, in crimes, the settlement is done by the aggrieved person himself. But if such person is a minor, lunatic, rude, then the person contracting on his behalf can settle with the permission of the court. If the person making the settlement dies, his legitimate representative can settle the settlement by order of the court. Quenching effect. When a settlement is reached in a case, it shall have the effect of acquittal of the accused. Vishwavan Das versus GC Hazarika AIR 1967 SC 995. In the matter of Sudhir Kumar versus MM Kuniram AIR 2008 NOC 1005 Kerala, it was held by the Kerala High Court that effect of compounding is that of acquittal of accused. Resignation can also be allowed in appeal in case of dishonor of check. KM Ibrahim versus KV Muhammad AIR 2010 SC 276. Important cases. Some important matters regarding compounding of offences are as follows. In the matter of Manoj versus State of Madhya Pradesh AIR 2009 SC 22, it was held by the Supreme Court that under Section 324 of the Indian Penal Code 1860, in case of conviction for causing injuries by dangerous weapons, the statement may be allowed if the parties have a cordial relationship. In the state of Ramlal versus State of Jammu and Kashmir AIR 1999 SC 895, it was held by the Supreme Court that compromise cannot be allowed in cases which are not compoundable under Section 320. The offence which is not excusable cannot be made excusable by order of the court. In the matter of Gulab Das versus State of Madhya Pradesh AIR 2012 SC 888, it was held by the Supreme Court that resignation cannot be done in such cases which do not come under the purview of Section 320. In such cases, the maximum quantum of punishment can be considered if the parties reach a settlement. In the case of Dimpy Gujrwal versus Union Territory of Chandigarh AIR 2013 SC 518, he was allowed to present his resignation in the non-compoundable offence because the offence was of a personal nature. The crime was common and was not against the society. In the matter of Rajendra Harakchandra Bhandari versus State of Maharashtra AIR 2011 SC 1821, it was held that in the offence of Section 307 of the Indian Penal Code, the production of resignation is not permitted. But the accused was ordered to be released on the sentence given because the case was 20 years old. The parties were farmers. They had reconciled. Overall, the main objective of this system is to maintain harmony in the society in the area of changing social environment and social change. The trend of mitigation is being promoted. Our judiciary has also recommended a liberal approach in such matter. Abdul Sattar versus State of Madhya Pradesh AIR 1981 SC 1775. What is victim compensation scheme? Let's discuss the arrangement made in the Code of Criminal Procedure 1973 regarding the payment of compensation to the aggrieved person. What is meant by victim? Let's explain it. The inclusion of the victim compensation scheme in the Code of Criminal Procedure 1973 is a product of the Code of Criminal Procedure Amendment Act 2008. By this amendment, a new section 357A has been inserted in the code to provide compensation to the victims of the offense. In fact, this system is the result of social change. It is well known that a person convicted of an offense is liable to be punished. He is punished with imprisonment and fine, but the victim of crime does not get anything. The victim of crime has to bear many pains and damages such as physical pain, mental pain, emotional distress, economic damage, medical treatment expenses, damage to reputation, etc. Mere punishment to the accused does not heal the wounds of the victim. Not only the victim but his entire family also gets into financial trouble. Keeping all these things in mind, it was assumed that compensation should be given to the aggrieved person to come out of the financial crisis. The provision of section 357 is the culmination of this. The text of section 357A reads as follows. Victim compensation scheme. Every state government shall, together with the central government, prepare a scheme to provide funds for the purpose of compensation to the victim or his dependents that have suffered loss or damage as a result of the offense and are in need of rehabilitation. Whenever a recommendation for compensation is made by the court, the district legal services authority or the state legal services authority, as the case may be, shall decide the quantum of compensation to be paid under the scheme referred to in subsection 1. If the trial court is satisfied at the conclusion of the trial that the compensation awarded under section 357 is not sufficient for such rehabilitation, or where the cases end on acquittal or discharge and the victim is to be rehabilitated, then that person can be recommended to compensation. Where the offender is not traced or identified, but the victim is identified, and where no trial is held, the victim or his dependent may make an application to the state or district legal services authority for compensation. On receipt of such recommendation or application, after making due inquiry, complete the inquiry within 2 months and award adequate compensation. First aid facility or medical benefits or any other interim relief to be provided free of cost by the state or district legal services authority, as the case may be, on the certificate of a police officer not below the rank of a police officer in charge of a police state or magistrate of the area concerned to alleviate the suffering of the victim, such order as the authority may deem fit forthwith. The Section 375A provides for being identified. This task of payment of compensation has been entrusted to the District Legal Services Authority and the State Legal Services Authority. In the matter of Lakshmi versus Union of India IIR 2015 SC 3662, the following guidelines have been issued by the Supreme Court regarding victim compensation. One is, in case of acid attack, a minimum of rupees 3 lakh should be given as compensation. Two is, they should be treated free of cost in government and private hospitals. Three, certificates should be given to the victims. For his compensation should be determined by the District Legal Services Authority. Compensation order. Order 357 of the Code provides for the order of payment of compensation. In Section 357, the order of compensation by the court is considered mandatory, whether it is positive or negative. If compensation is not ordered or refused, reasons to be recorded in writing. Ankush Shivaji Gaikwad versus State of Maharashtra, AIR 2013 SC 2454. It is said under Section 357(1) that where a court sentence of fine or any such sentence of which fine is also a part, such fine shall be applied as follows: to pay the expenses reasonably incurred in the prosecution, to persons who have suffered loss or damage by that offense and who cannot obtain such compensation from a civil court. In the payment of compensation for injury caused to any person by such death on conviction in cases of causing or abatement or to death, when such compensation is entitled to be received under the Fatal Accident Act 1955. In the payment of compensation in case of theft, criminal misappropriation, criminal breach of trust and fraud to a person who is a bona fide purchaser of property relating to such offense. According to subsection 2, if a sentence of fine is awarded in any matter which is appealable, compensation shall not be paid unless the period allowed for presenting the appeal has not elapsed or appeal is made until such appeal is decided. Subsection 3 provides for the payment of compensation to the injured person when no sentence of fine has been passed by the court. The order under this section can also be given by the appellate court or the High Court or the Court of Session, exercising the powers of revision. It is also to be mentioned here that the order of compensation can be given only after the accused is convicted. While passing the order for compensation to the aggrieved person, the court should exercise its powers too generously as to serve the purposes of justice. For this, one is financial condition of the parties, two is the nature of the injuries, and three is the facts and circumstances of the case should be taken into account. Hari Kishan versus Sukhveer Singh, AIR 1988 SC 2127. In the matter of Balraj versus State of Uttar Pradesh, AIR 1995 SC 1935, it was held by the Supreme Court that compensation is not part of any punishment but is in addition to it. In case of Mangilal versus State of Madhya Pradesh, AIR 2004 SC 1280, also it has been said that before ordering compensation to the aggrieved person, the accused should be given an opportunity of being heard. In the matter of R. Vijayana versus Baby AIP 2012 SC 528, it was held by the court that compensation could be paid out of fine. In the matter of Balbir Singh versus State AIR 2020 SC 4193, it was held by the Supreme Court that he is entitled to compensation for the damage caused to the complainant when he is illegally tortured by the police. Excess of compensation. It is provided under section 377B that the compensation payable by the state government under section 357A of the Indian Penal Code 1860 shall be, in addition to the payment of fine to the victim under section 326A, section 376AB, section 376D, section 376, section 376DA, section 376DB, inserted and substituted by the Criminal Law Amendment Act 2013 and 2018. Treatment of victims. It is provided under section 357C that all public or private hospitals, whether maintained by the central government, state government, local bodies, or any other person, shall immediately provide free primary or medical treatment to the victims of an offence falling under section 326A, section 376A, section 376AB, section 376B, section 376C, section 376D, section 376DA, section 376DB, section 376E of the Indian Penal Code 1860, and will immediately inform the police about such incident. Substituted by the Criminal Law Amendment Act 2018. What is the meaning of victim? The definition of the word victim has been given in section 2 of the Code of Criminal Procedure 1973, namely, the term victim is defined under section 2WA of the CRPC 1973 as a person who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been changed, and the expression victim includes his or her guardian or legal heir. In case of Dr. Kunal Shah versus State of West Bengal AIR, AIR 2015 Calcutta 370, a person is treated as the victim whose wife has died due to medical negligence. In the matter of Naval Kishore Mishra versus State of Uttar Pradesh AIR 2019 SC 3352, it was held by the Supreme Court that the word victim includes the victim himself, his guardian and legal heir. Let's explain various modes of alternative disputes resolution system. What are the various alternative disputes resolutions techniques should they be wholeheartedly promoted in India? It is well known that our present judicial system is very expensive and delayed. The parties to the dispute have to wait for justice for years. Due to this, it is natural to lose faith in the justice system. These weaknesses of the judicial system have given rise to alternative methods of settlement of disputes. When justice started getting faster by alternative measures, then the practice of these measures increased day by day. Before proceeding, it is pertinent to mention that alternative means of resolving disputes are not a substitute for the present formal judicial system, but it is a supplement to it. Alternative methods of dispute resolution. Following are the main alternative methods of dispute resolution. One is negotiation. Negotiation is the first alternative method of dispute resolution. It is the simplest and least costly method of settlement of disputes. In this, both the parties sit together and discuss their dispute and work to find a solution to the dispute. There is no interference of any third party. In mutual negotiations, if the party talks with a clean heart and restraint, then the possibilities of getting a solution become strong. Interaction is expected to take place in a cordial atmosphere. If neither party makes the dispute a question of prestige, then the resolution becomes easy. Conciliation and mediation. Conciliation and mediation. Another alternative method of dispute settlement is conciliation and arbitration. When the parties fail to resolve their dispute by mutual negotiation or negotiation, the assistance of a third person is taken. Such third person is called conciliator or mediator. He is such an impartial person who has nothing to do with controversy. He makes efforts for dialogue and reconciliation between the parties. He also gives suggestion for settlement of the dispute on his behalf and uses his goodwill and influence. Mad arbitration. The third alternative method of dispute settlement is mad arbitration. When the dispute is not settled by negotiation, then a third person is authorized by the parties to settle the dispute, and the decision of such third person is binding on both the parties. It is not a remedy which is not governed by the act of arbitration, nor does it have any kind of formality. In this, the reference to the dispute is made informally. Medulla. When it becomes impossible to reach an agreement by arbitration, the medulla is resorted to. It is a process in which the mediator takes the place of the arbitrator and he makes fair selection of some of the suggestions proposed by the parties during negotiation and is binding on the parties. Such a person tries to find an arbitral route during the negotiation and tries to persuade the parties to it. Mini trial. Some trial is also an important alternative remedy for settlement of disputes. It is different from formal litigation. In this, a fair person is elected by the parties. The parties present their side before him, give their arguments, and also present evidence in support. That impartial person gives his conclusion after hearing both the sides and persuades both the parties to agree on that conclusion. The party trusts such a person and accepts his opinion because such a person is fair and honest and gives his opinion after listening to both the sides. Arbitration is an effective alternative remedy for settlement of disputes. In this, the dispute is referred to the arbitration by the parties to the dispute. Arbitrations are also appointed by the parties to the dispute. Arbitration is passed by the arbitrator after giving an opportunity of being heard to both the parties. When such an award is final, it is binding on the parties like a decree of the court. Arbitration and Conciliation Act 1996 provides for arbitration only. A form of arbitration is also rapid arbitration. In this, the arbitration proceeds at a fast pace and within a few days the dispute gets resolved. It is commonly used in resolving trade and commercial disputes. Pre-trial conciliation. These days, the practice of pre-trial agreement has also increased. It was first started from the state of Himachal Pradesh and now it is being followed in most of the states. In this, an attempt is made to settle the matter before starting the trial. A provision has also been made in this regard in the Legal Service Authority Act 1987. Lok Adalat is the most popular of the alternative methods of settlement of disputes. Now, Lok Adalat has also got a legal form. Innumerable cases have been started by Lok Adalat by quick and low cost. Detailed material about Lok Adalat is given in upcoming question and answer. Benefits of alternative measures. There are several reasons for the increasing importance of alternative methods of settlement of disputes as there are several reasons for the increasing importance of alternative methods of settlement of disputes such as it is a proceeding of extrajudicial nature. The technical rules of the Code of Civil Procedure and Evidence Act do not apply to this. Through them, disputes are resolved quickly. This is a less expensive system. There is no need for lawyers. The parties themselves appoint conciliators and mediators, which reduces the chances of favoritism and corruption. All the proceedings of the parties are conducted in a cordial environment, due to which the relation between the parties remain cordial. Under these measures, neither party loses nor wins. About Lok Adalat, it is said that the essence of Lok Adalat neither win nor loss. This arrangement lightens the workload on the courts. Its importance in India. Alternative methods of dispute resolution are most needed in India. Here, innumerable cases are pending in the courts, whose disposal takes a lot of time and the expenditure is also high. On 25 February 2001, it has been told by the then Law Minister Arun Jaitley in the Parliament that 2 crore 34 lakh cases are pending in various courts of India. It is necessary to resort to alternative measures for their speedy disposal. This is also one of the main reasons for the passing of the present Arbitration and Conciliation Act 1996. Increasing number of cases in court, delay in trial, there is a need to promote alternative measures in India due to highly costly arrangements, etc. Then India is an agricultural country. There is a majority of agricultural people and villages. Most of the people are illiterate and poor. Therefore, for these reasons also, alternative methods of disputes resolution can prove to be a boon for India. Social movement is a powerful platform for social change. What is a social movement? How many types is this? Let's describe its main feature. India had always been famous and in the forefront of social movements. There have been social movements in India for various types of evils, malpractices, superstitions, social, economic and political consciousness, etc. Swami Vivekananda, Dayanand Saraswati, Ram Krishna, Paramhansa, Bal Gangadhar Tilak, Vinoda Bhave, Mahatma Gandhi, etc. are considered to be the pioneers and leaders of social movements. They have hit hard on the evils and malpractices prevailing in the society through social movements such as dowry system, child marriage, death feast, slavery, exploitation, etc. Social movements have been considered as a powerful platform for social change. He has made an important contribution towards social reform. Whenever there is a social movement, one or the other social change can be imagined. Social movement can also be called a public conscious movement because in this a large number of people make collective efforts for any social change. It can be said about social movement that one is they are collectively operated by a large number of people. Two is it is headed by a single person. It aims at social change. It is often long lasting. It is generally non violent. There is a sense of public interest in this. It is considered a form of social service or public consciousness. What are its types? Every social movement is motivated by one or the other purpose. He has his own plan and goal. The agitator also has his own interest. This is the reason that many types of movements have been involved in India, such as social, economic, political, religious, cultural, etc. There is some background behind all these movements. This refers to different types of movements. Generally, the movements are of the following types. One is general and specific social movements. To each social movement can be general or specific. According to Herbert Blumer, general social movement is not aimed at any one particular goal but is motivated by a general purpose. It doesn't even get organized. Most of the people are not even interested in such movements. There is a lack of equality and coordination in the conduct and behavior of the person associated with such movements. In fact, such a movement cannot be called a social movement. On the other hand, a specific social movement is an energetic collective social movement. It has a purpose or goal of its own, such as social, financial, political, religious, academic, cultural, etc. Because in such a movement they get organized and participate enthusiastically. Such movements also have an impact on the people, governance and administration. Normative and value-based social movement. Neil J. Smeltzer divided social movements into two parts. One is norms-oriented social movement. Two is value-oriented social movement. In fact, these two movements are related to each other. That is, they are complementary to each other. In these movements, the movement was started by stating the goal of social change or restoration of social values and setting the standard. In other words, it can be said that standard-based social movement is done for the restoration or realization of social values. Reformative and revolutionary social movements. Every movement is either reformative or revolutionary. The two movements generally seem similar in nature, but fundamentally there is a slight difference between them. Reformation movement is done to implement the existing social values in some corrective form while keeping them unchanged. In the reformative social movement, the existing social values are not tampered with, only slight changes are made in them according to the country, time, and circumstances. Whereas, on the other hand, in the revolutionary movement, efforts are made to replace the existing social values with new social values. This movement does not accept traditional values. A social movement on values, power, and participation. Tumor and Colon have further mentioned three types of social movement. One is price movement, two is force movement, three is participatory movement. In the value-based movement, the agitators run the movement for social change, keeping the criteria of success. The power-driven movement is run with the noble aim of getting some power. In other words, it can be said that in the power movement, special attention is paid to gaining power. In participatory movement, the agitators become participants in to make some social changes. Such movements for social change can be as follows: reactionary, moderate, liberal, conservative. Recreationary and conservative social movements. According to Killian, there can be three forms of social movement. One is recreationary, two is progressive, three is conservative. The reactionary agitators agitate for the restoration of previously existing or established social activities in the direction of social change. They want to restore the pre-established social activities. Progressive agitators agitate to establish a new social order. They want a new social order. Conservative agitators are in favor of existing social values and norms. Bachpan Bachao Andolan. The Bachpan Bachao Andolan is active for the protection of the interest of adolescent children. In the matter of Bachpan Bachao Andolan versus Union of India, AIR 2011 SC 3361, it was held by the Supreme Court that arrangements should be made to rehabilitate the children coming out of the circus. What are its characteristics? Social movement has its own characteristics, which can also be called characteristics of social movement. Some of the main features of social movement are as follows. One is sharing common goals and values. Social movements are carried out for a common purpose and for the protection of social values. In them, the interest of a particular community or class remains vested. This is never done for personal selfishness. At the same time, social change is done to protect the values, that is, social values remain behind the social movement. From this becomes clear that social movement is a collective effort. A large section of the society participates in this. A social movement cannot be run by a single person. Behind it lies the support of the public. When many people come together to do some movement, then a sense of cooperation and harmony arises among them. Unity and organization also get support. Then there are some norms of social movement. Every agitator remains dedicated and loyal to these standards. He can't go beyond these standards. Longevity and enormity. The social movement is usually large and but like duration, largeness is only relative. Some social movements extending over a span of many decades may enlist hundreds or thousands of members. Some movements take place within the boundaries of a specified secondary group. such as a religious association of a local community, and may include only few score or a few hundred members. The members and duration of the social movement are not fixed. Its members can be maximum and minimum. It depends on the nature of the social movement. Lack of formal process. There is no formal process of social movement. Most of the social movements are run in a simple and normal way, such as the number of their members is not fixed, the eligibility of the members is not ensured, duration is not specified, they have no legal power. Some members are permanently attached, some join the movement temporarily, some have their own formal structure such as club, corporation, political parties, etc. Lack of stability and security. The social movement is not stable and secure in its existence. The reasons for its not being permanent and safe are as follows. There is always tension in such movements. There is a risk of conflict between the members. There is no coordination of ideas among the members. There is no security in government administration. The tendencies of divisiveness among the agitators may work. Sometimes attempts are made to suppress them, even by the government administration. Field of social movements. The scope of social movement is very wide. They can give their services in many fields or they can serve the society through social movements such as social welfare services, remedial services, preventive services, family welfare services, child welfare services, protective services, services to the helpless and handicapped, natural disaster related services, vigilance services, medical services, etc. What legal provisions are given for the maintenance of parents, wife, and children? Let's explain. A person must maintain his parents, wife, or children even by doing 100 bad acts. Manusmriti said, explain the statement. What legal a person must maintain his parents, wife, or children even by doing 100 bad acts. According to Manusmriti, from the very start, it is considered a moral and pious duty of person to arrange maintenance for his parents, wife, and children. Manusmriti had description that वृद्धोचे माता पितरो साध्वी भार्या सुत शिशु आप कार्य शत कृत्वा भृत्वा मनुर्वीन. For example, so maintenance should be given to parents, wife and children by doing 100 works. But later, this concept has become foggy. Parents, children and wife are being ignored in family. Consequently, The necessity was felt to provide this moral duty to a constitutional form. So provisions relating to maintenance were made in Criminal Procedure Code 1973, Hindu Adoption and Maintenance Act 1956 and Muslim Women Protection of Rights on Divorce Act 1986. In charging today's changing world, it has become a legal duty of a person to maintain their parents, wife and children. In this way, one another revolutionary act was passed. Maintenance and Welfare of Parents and Senior Citizens Act 2007. This law had wide effect on the society. The feeling of security developed in all parents, wife and children maintenance under Criminal Procedure Code Section 125 to 128 of Criminal Procedure Code 1973 had provision regarding maintenance. Under Section 125, following persons are eligible to get maintenance. One is wife who is unable to maintain herself, two is minor child, either legitimate or illegitimate, or married and unmarried, who are unable to maintain themselves. Such legitimate or illegitimate child except married daughter who has unable to maintain themselves due to physical or mental weakness. Parents who are unable to maintain themselves, such person who has ignored his parents, wife or children and has sufficient means or sources is liable for the maintenance of parents, wife or children. Sumitra Devi versus Bhekam Chaudhary AIR 1985 SC 75. In this matter, illegal child who is minor is considered eligible for maintenance. Rohtas Singh versus Srimati Ramindri AIR 2000 SC 952. In this matter, a divorced wife was considered eligible to get maintenance from his ex-husband after divorce, no matter if the grounds of divorce were the desertion by wife. Same decision was given in Shahabano Begum AIR 1985 SS 945. Srimati Tejswini versus Arvind Nejra AIR 2010 NOC 228 Karnataka. In this matter, it was said that wife shall not be deprived from maintenance on the grounds that she is highly educated. Mahesh Chandra Trivedi versus State of Uttar Pradesh AIR 2009 NOC 205 Allahabad. In this matter, wife is considered eligible to get maintenance till remarriage when divorce was taken on mutual consent. Dr. Shrimati Vijay Manohar Arbat versus Kashirao Rajaram Swai AIR 1987 SC 1100. In this matter, it was also considered the duty of married daughter to maintain their parents. T.C. Baburao versus Kumari T. Seria AIR 2010 NOC 330 Andhra Pradesh. In this matter, unmarried daughter, even after majority, is considered eligible for the maintenance. Lalit Mohan versus Tripata Devi AIR 1990 Jammu and Kashmir 7. In this matter, even husbands are considered eligible to get maintenance from wife. Rafid Ween versus Srimati Sleha Khatun AIR 2008 NOC 776. Bombay. It was decided in the matter that on being alive of husband, a mother can claim for maintenance from his son. But wife cannot claim for maintenance in such situation when she refuses to live with husband without reasonable reason. Husband and wife living separately by mutual consent. Date of application or date of order. The amount of maintenance shall be such which magistrate deemed fit. Maintenance of divorces, maintenance of divorcee Muslim women. Law is different for the maintenance of divorcee Muslim women. Muslim women, protection of rights on Divorce Act 1906 applies on such women. According to Section 3 of this Act, divorced Muslim woman is entitled to get maintenance from their husband till iddat, not later. Divorcee Muslim woman shall be entitled to get maintenance after iddat from such person who shall acquire her property in succession. If such relatives are unable to give maintenance, then she will get maintenance from way board of that state. But in many judicial decisions, the system of maintenance till iddat is not considered lawful. A. Abdullah versus A.B. Maimuna Shahid by AIR 1988 Gujarat 141. Children of Muslim women can get maintenance under according to the section 125 of Criminal Procedure Code 1973. Muhammad Abdullah H. Uraf Farooq Pash versus Saliha Khatun AIR 2007 NOC 737 Bombay. Maintenance under Hindu Adoption and Maintenance Act. Section 18 to 28 of Hindu Adoption and Maintenance Act 1956 was provision regarding maintenance. According to Section 18, a Hindu wife shall be entitled to be maintained by her husband during her lifetime. Balachandra versus Padmavati AIR 2010 NOC 716 Madras. In this matter, Madras High Court said that if wife does not have own property or no means of heiring, their wife is entitled to get maintenance under Section 18. In certain situations, wife can get maintenance even if living separately from husband. If husband is willfully neglecting wife, if husband is being treated with cruelty, if husband suffering from leprosy, if he has any other wife living, if he keeps a concubine, if husband does conversion to another religion, if any other cause justifying her living separately. According to Section 19, a Hindu wife shall entitled to be maintained after the death of her husband by her father-in-law. According to Section 20, a Hindu is bound during his or her lifetime to maintain his or her legitimate or illegitimate children or aged or infirm parents. Every dependent person is entitled to get maintenance from the person upon whom he or she depends. Here it is provided that in this act, provision of interim maintenance is also mentioned. Indra Soni Balnam Satyanarayan Maruti AIR 2002 NOC 203 Delhi. In this matter, it was decided that if husband-wife living in foreign and on demand of wife to return to India, she cannot be deprived from her right to maintenance. Before determining the amount of maintenance following should keep in mind that position and status of relationship, wants of dependents, number of dependents, source of income of the person who shall maintain, value of property of deceased. Thus, due to the system of maintenance among wife, aged or infirm, parents, child or dependents under Hindu adoption and Maintenance Act, the feeling of security developed in them. Maintenance under Maintenance and Welfare of Parents and Senior Citizens Act 2007 for the purpose of maintenance. Maintenance and Welfare of Parent and Senior Citizen Act 2007 is a revolutionary social legislation. Under this act, maintenance guarantee is provided to aged parents and senior citizens. Under Section 4 of the Act, following persons are entitled to get maintenance from their children. One is parents, two is grandfather, three is senior citizens who is unable to maintain himself. Purushottam Das, Batra versus Family Court, Jaipur AIR 2007, NOC 898, Rajasthan. In this matter, Rajasthan High Court decided that parents are entitled to get maintenance from their son. It is duty of son to maintain them. Panna Lal Hajra versus Full Money, Hajra AIR 1987, Kolkata. 368 in this matter, Kolkata High Court decided that aged and infirm parents are entitled to maintenance from their children. Childless stepmother is also entitled to maintenance from her stepson. Following things should be keep in mind while awarding amount of maintenance. Wants of parents and senior citizens, expected amount to lead a normal life, living standard of parties, economic condition, other conditions, etc. Thank you, all my brothers and sisters, ladies, gentlemen, students, scholars, teacher, trainers, professor, professional, officer, official. I thank all respected doctors and directors. I thank all honorable minister manager. I thank all honorable advocates, advertisers, administrators, and advisors. Last but not the least, I would like to thank the most honorable President Prime Minister Modi ji. Thank you very much. Dear friends, tomorrow we will read right to adoption is a constitutional right under Article 21. We will explain the statement. A childless person must arrange a son by any way. Dharam Sutra. We will describe the law mentioned about adoption in India. Adoption is a traditional system of Indian society. Thank you. Thank you very much.